Hi, good evening, everyone, and welcome to another of our medical legal talks in our series of CPD for you. And tonight, I'm very pleased to introduce another topic which has not been covered before, and this will be on medical notes, the duty of candor, and their impact on negligence claims. I'll bring on the speaker shortly, but just to introduce, she's Miss Krishantini, uh, and she is specializes in medical legal matters, and she will be presenting roughly about half an hour on this topic, and then we'll open up for questions and answers. Now, if you look at the description of the video, I've put a link to the medical legal playlist. So if you want to view our previous medical legal talks, you can view the playlist. And if you want to stay informed of our upcoming CPDs in the future, please subscribe to our channel and hit the notification bell so you'll stay informed whenever we schedule something. Okay, so we are very thankful to Dr. Shield for helping us organize the talk. So while we get things organized in the backstage, just a very short clip about Dr. Shield. Okay.
We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Okay, we're back. Just some housekeeping slides. But before I continue, I see one like there. Can you smash the like button, as all these YouTubers say on Facebook, if you're watching on our Facebook Live in our group? Because by hitting the like, you will help the algorithm, spread the video so that our colleagues can take notice. Okay, some of you sometimes come in late. Okay, so please don't forget to hit the like button, please. That'll really help the video spread. Okay, now just the housekeeping slides. You can ask your questions later in the comment section of either YouTube or our DOBBS Facebook video, which is streaming live now. But we also have Slido. So this is the code for Slido, 733732. If you open your Slido app or visit slido.com and enter 733732, you will go to the Slido event, and that's where you can ask your questions as well. Okay, I have actually a little poll. I don't know if you are already watching. Those of you who are just come on, I will switch and move to the Slido. And can you take the poll on our... Okay, can you see that, the Q&A? Now, I just want to know who's watching. So if you can switch to Slido, you can use the QR code and scan, and that will take you to slido.com, code 733732. just to warm up a little bit. Can anybody can take a vote? Yeah, thank you. Got one. Any more? Any GPs out there, specialists, medical officers? Actually, if you are using a mobile phone to watch, it can be a little bit awkward, but you could switch out to Slido and then do the take the poll. Okay. From past experience, a lot of you come in late, so just warm up so that we give time for those of you to catch up with our stream. Okay. Yeah. Thank you. Yeah. 1/3, 1/3, 1/3. No GPs. Everybody's still working hard these days in their clinics at night. Okay. All right. Okay, it's just a warm-up session, and also to get people online. Okay, so let me go back to the housekeeping slides. So the actual points would be displayed. You can claim the points at the end of the talk. I'll be displaying a QR code, and you can use, as usual, scan. But I'll also be putting keywords throughout the talk, so you can claim the points even though the QR code expires, which normally it expires about an hour or so after it's generated. So if you're watching the talk not live or even tomorrow or 1 week later, you can still claim your points by entering the keywords displayed in the correct order using the multiple choice question module in our CME board, okay, at dobbs.my. Okay, if you're not a member, please register. Membership is free, and you can access the board as a member. Okay, and we will put the QR code in the blank space here. Okay, now let's go back. So I'd like to bring on board our esteemed invited speaker, Miss Krishanti. And hello, Krish.
Hi, Dr. Alan. Hi.
Yeah. So thank you so much for speaking to us tonight. Maybe just as an introduction, would you like to tell our audience a little bit about yourself, where you practice, and what you do?
Yeah. Sure. Thank you, Dr. Alan, for having me on, and thanks to Dr. Shield for the invitation as well. It's my pleasure to address you all today. My name is Krishanti. I've been in legal practice since November 1997, and I do a mixed bag of work, medical negligence litigation, and insurance in general, and general litigation, but mostly litigation. And I'm a partner at the firm of Murali B. Pillai and Associates. So I look forward to sharing what I've got to share today with you all.
Yeah, okay. I think it's a fresh topic. We've not covered this before. Medical notes and about Candor. For those who don't, English is not so powerful. Maybe the standard is dropped a bit. Candor means honesty, as like in being candid. Is that?
Yes.
So that's interesting. So we like to hear your talk to know whether honesty is the best policy when it comes to medical notes. And okay, without further ado, I'll share your screen and I'll remove myself, and the stage is all yours, Krish. Okay.
Thanks, Dr.
Okay. So go ahead. Yeah, all yours.
Yeah, I will just take you there, right? Medical notes. It's important for you to keep accurate notes because your notes will form the basis of your diagnosis, of your how you choose to treat your patient. And if, unfortunately, if something were to go wrong, your notes would be the basis on which it would later be reviewed what occurred. And also, in the heat of the moment, if you've got an emergency, your past history that you've taken of the patient might inform the treatment that you're going to give the patient. So notes are essential. both what you write today and what you've written in the past. So accurate records are important. Of course, most hospitals and clinics will right up front take the details of the age, sex, IC number, address, next of kin, contact information. Many clinics also have sections for allergies, medical conditions, and any other ailments that the patient might have. But we don't always have standard format. So if that is missing, or you don't have a standard format for those things, you need to note it down. So as the doctor or dentist treating the patient, you take down what's missing. So I would suggest that notations at the basic contain the following information. Firstly, the date and time of the visit. The second bit that I put here, the age, weight, and height, is not generally necessary unless it's relevant to the patient. Often for pediatric cases, that would be quite relevant. And it might be relevant also in terms of a medical condition where obesity is relevant. The other thing you would record is if the patient is coming with someone, you might want to note who that person is, especially if it's a minor child. So the patient is accompanied by the mother, the father, the aunt, sister, the brother, because quite often the person accompanying is also providing information. Alternatively, if you have a person who's mentally incompetent, clearly the information is coming from the caregiver. So the caregiver's information should also be input in the notes. Sometimes you have cases where a spouse might come along and the spouse might actually be quite active in the consultation, maybe providing information or might influence the patient's choices of treatment. If it becomes clear that during the consultation that the person accompanying the patient is having a more than usual influence on the choices of treatment or decisions the patient is making, it might actually be a good idea to note that down. Especially if the person accompanying is maybe dissuading the patient from the course of action that you've recommended. So the next thing would be, of course, the record of the complaint or for the purpose of the visit, whether it's a follow-up or an initial consultation or a referral. So you would put that down. You would, of course, take the patient's medical history, and you would note your diagnosis based on the history you've taken and your examination, and a quick notation on why you came to that diagnosis would be relevant, unless of course it's a simple thing like person has a cough, cold, diagnosis flu. But if it is something more complicated, perhaps a quick notation of why you've come to that diagnosis. Then the treatment options that you provide to the patient should be noted. That's very important. And the risks and benefits of these treatments should also be advised to the patient and also noted in your notes in point form. You don't have to go into full and lengthy detail. Also, often there's a case where you might be talking about surgical or some other invasive form of treatment or something that's a bit high risk. So it's always advisable that the patient be given the option of seeking a second opinion wherever possible. Of course, if it is a life-threatening condition, a second opinion may not always be possible. But if you are in a hospital environment, it is quite likely that a second opinion could immediately be got from a colleague. So if there is the time to do that, a second opinion should be offered. Then, of course, once you've discussed it and the patient has decided on their option, you would note down the option and then set out the treatment plan. If the treatment is prospective, meaning in the future, you would note down what's to be done. If it is a procedure being done on the spot, for example, maybe it's stitches to a cut chin or something, after the procedure is done, you would put your notations about how many stitches, what the appearance of the wound, and whether the bleeding was heavy or it stopped quickly. All these things, the features of the procedure would need to be noted. And of course, after or at the end of the consultation or the treatment, your next scheduled visit or any parting advice should be noted. For example, any medication or advice to rest or perhaps take a day off work should be noted. Unusual features of the consultation should also be noted. For example, I mentioned earlier the influence of the accompanying person. If it's unusual, you should note that. Or if the patient if the patient refused treatment, of course, you should note that. Or if the patient expressed fear or an unusual reaction or worry towards the situation of what's advised, you could note that, but not for every patient. A certain level of fear or worry is normal, but if it's abnormal, anything that you note that's abnormal should be noted in the minutes. This sounds like a lot, but if you notation can be an art. You can pare it down, bring it down to the minimum. You probably develop your own styles on how to write it quickly and in as few words as possible. Perhaps you might use short forms, acronyms, things that you would know the meaning of. By all means, utilize it to speed the process along. Here's a sample notation of a complaint of a person with backache. So they've come to see an orthopedic surgeon, for example, about a complaint for backache. So if you can see here, on the left is the date and the time of the visit, and the complaint is listed as a backache for 1 week with shooting pain down left leg, and the backaches experience off and on over 1 year, and more frequently in the last 2 months. So the patient has seen the physician for pain previously and was given non-steroidal anti-inflammatory drugs and did not get any relief. So this patient had an MRI on the 2nd of January of this year, and the findings of the MRI were a lumbar herniated disc. So the patient was referred to the treating doctor by Dr. A. So the consultation here was conducted in the Mandarin and English language, and the patient's medical history was that of bronchial asthma with no known allergies, and the patient was not currently on any medication. So you've got the history here, you've got the explanation of the language in which the consultation is conducted. This is important because you might write your notes in English or Bahasa Malaysia or whatever language you are writing in, but the language in which you record the notes is not necessarily the language in which your consultation is conducted. So as a rule of thumb, if you are if you're conducting the consultation in a language other than that which you are recording in, you should note the language of the consultation. In fact, for completeness of record, even if the consultation was in English, it'd be good to just note consultation in English. So then this patient was offered the following treatment options. The conservative treatment, which was rest and in further course of anti-inflammatory medications. In this case, the advice given was it was not advised as the previous effort failed. So here you have the option offered and the recommendation for that option. Next, you have the epidural steroid injection as an option, and the procedure was explained to the patient. You don't have to note down the detail of the procedure, just note that the procedure was explained. And the risks The risks here in this case was the relief could be minimal or temporary. Nausea, headache, or dizziness might ensue from the injection. The other option offered in this case was a microdiscectomy, and the procedure was explained. And the risks here that were advised were infection, nerve injury, recurrence of hernia, bleeding, pain, but pain may still persist. If you are able to, have a shorthand or short form writing that speed this along, please do it. As long as you are able to read your notes and your nurses are able to read your notes, that's fine. So at this point, when the options were given, the patient was informed that she could seek a second opinion. This patient declined. Some patients may say yes, they want to, and you then give them the option to go and see another person, and you can either on the same day in the same hospital, or they can go and see somebody else they choose, and you can fix an appointment for the next day for them to come back and decide. So in this case, this example, the patient decided to choose the steroid injection. So the plan here is patient chose steroid injection. Procedure scheduled for the 4th of January 2021 at 9 a.m. And this was the instruction, nothing to eat. Nothing to be eaten 6 hours prior. Okay. Now, why is it so important that you take detailed notes like this? Often doctors sometimes rely on the standard consent form provided by hospitals. If that consent form is detailed and provides you space to fill in details like the risks and benefits and the options offered, that's fine. But sometimes it's a very standard form which simply says patient has explained the risks and understands them, and then there's a place for the signature, and only like 1 or 2 lines for you to mention the procedure. If that is the case and that's a form that's used in your clinic, then your notes are very much more important, because it is risky to rely solely on the consent form, as can be seen in the decision of Dr. Hari Krishnan against Magat Norisha. In that case, the consent form only contained general precautions, and the doctors had not noted in their notes that there were certain risks. In this case, the court focused on the risks of bucking and blindness. And since there was no evidence of that risk being advised, the patient said that this was not advised to me. It was found that the treatment advice was incomplete, and it was improper, and the negligence was found against the doctors. In this case, it was unfortunate. The award was pretty high. There was an award of aggravated damages. So that's the notes. I will now move on to the duty of candor, the duty to be honest with your patients. I will come back again to the notation portion, because it ties up both the accuracy of your notes and the subsequent conduct towards the patient in terms of giving information, whether verbally or in writing. It will all tie up and join together. You'll find that in your note-taking, you also have to be candid and clear. That's important to always be clear. So the duty of candor is both an ethical duty and a common law duty. Common law meaning you can find it within the case law, in the law developed in the courts. So the ethical duty for doctors can be found in the Code of Professional Conduct. Your most recent one is the 2019 code. I've pulled out certain excerpts of the various sections. The first is section 2.1.4.5, which has to do with medical records and clinical notes. This first portion is about maintaining the notes, keeping a record, and keeping it safe and secure, and basically giving access to the notes to the patient and to the courts as required. This second portion is where the ethical duty comes into play. A practitioner must avoid the erasing, obliterating, tampering, or altering of previously made entries in the clinical records, as these may be interpreted as attempts to cover up management errors or adverse events. So you've got to be accurate in your notes, and you cannot erase them, block them out, change them in any way. Or it might be seen as hiding mistakes. And this ties in with your note taking. It must be accurate and not tampered with. And it ties into your duty of honesty towards your patient. It's put, this duty of honesty, it of course helps in the management and treatment of the patient subsequent to the adverse event. So if it's all there, their future treatment, there will be better outcomes. And also in helping the patient come to terms with what may have occurred. Section 2.1.5 is the medical records. Here, essentially, you have a duty to provide comprehensive medical reports as requested by the patient. So sometimes when things go wrong, the patient will ask you or write to you for a report on what had occurred. And it is important that the patient or their next of kin or the caregiver or parent of a minor or disabled person be given the proper information. Refusal to give it, withhold it, or give excuses such as we won't give it to you unless you pay fees, as you can see, has been is unethical under the doctor's standards. Section 2.6 is about medical errors and incident reporting. So in this case, once an error has occurred, the error and the management should not be concealed from the patient. The patient or persons in authority. Persons in authority might be the hospital ethical board or the Ministry of Health or any inquiry, official inquiry into the event. And these events must be reflected in the notes. Again, there must be honesty in the recording of the notes. This is the duty of candor. You must be truthful and honest in recording your notes. The Good Medical Practice of 2019 that's put out by the Malaysian MMC has a guideline for practitioners on what ought to be done in a case of adverse outcomes. It's quite lengthy, so I've not reproduced it here, but it is a useful go-to resource for what you should do in the event of something unwanted occurring, untoward occurring. So you might want to brush up on that and keep that handy in your office. Now, coming to the common law duty of candor, this is where it has developed through the case laws. It is a concept that has its roots in both ethics and the fiduciary duties that might be owed by the various professions or persons in positions of power or confidence or advantage over others. So it's not just doctors who owe these duties. Professionals who find themselves in positions of power over others. For example, a lawyer might also have, they find themselves in positions of confidence. Financial advisors also are in positions of confidence in relation to their clients. So I've put a few examples in the cases that come after this. Both doctors, lawyers, and a person who generally has authority or power or confidence over others. This first one speaks of the relationship of confidence. This was a case of an Englishman who was a Muslim convert who wanted to help the Muslim community after World War II in England. So he was persuaded by a Muslim, a man named Spurney, to purchase Spurney's house in London for the purposes of creating an Islamic cultural center. But the terms of sale were very favorable to Spurney. The property was priced far in excess of its true value. He was entitled to continue to reside there for very low annual rent. And he was also entitled to substitute the property with another at any time prior to completion of the sale transaction, and without regard to the condition of the substitute property or the relative value to his current property that's being considered for the sale. So it was a very uneven agreement in that Spurney had all the power and all the benefit, and Tufton had very little. So the English Court of Appeal held, you can see here, that because of this relationship of confidence, Spurney held himself out as an experienced Muslim who could help guide Mr. Tufton, who was a new convert, in helping the Muslim community in London at the time. So he had a position of confidence. Tufton had confidence in Spurney. So the court held that because of this relationship, he owed him a duty of honesty. And in this case, Spurney breached that duty of honesty. So the Court of Appeal just set aside that purchase because he abused that position of confidence that he had with Tufton. Now, this case, Dato Haji Azman Mahalan versus PP, was a criminal case. And this was a case where they talked about the duty of candor owed by the public prosecutor and also lawyers in general. And because of their professions, they have a duty to ensure that justice is done, that the decision be one that is in accordance with the truth. So all the facts that are relevant and pertinent to the case should be put before the court, and nothing should be withheld. So the court observed that there was a duty of candor resting on all professionals, whether it was the DPP or the counsel for the state or the counsel for the accused, to be candid with the evidence so that the court arrives at a just and fair decision. Now, there was a recent case, Yap Sao Leong and another versus Kerajaan Malaysia and others. It's a High Court case just last year, where the High Court judge had held that while the MMC had no specific guidelines on the duty of candor, it had its good medical practice, samples of what I just shown you earlier, and it contained a statement that when an adverse event occurs, a doctor is under an obligation to inform the patient and or relative the causes and what happened. So this is the case for medical professions. In the context of litigation, there is also a duty of candor, because Yap Sao Leong is about being candid in informing the patient what has happened when things go wrong. This case is about being candid in the course of litigation. So if you can see the case Chen Hoi Shan versus Professor Dr. Al-Jafri Abdul Majid and others, cited the English case of Naylor versus Preston Area Health Authority, where it held, and there's quite a lot here, but basically what it is as a medical professional, once you are in court, you have a duty to disclose the information so that parties can arrive at a proper understanding and conclusion on what had occurred. And this is particularly so that the judges had said that in professional negligence cases, and in particular in medical negligence cases, there's a duty of candor resting on the professional man to be candid, to give a true account of what occurred. Now, the duty of candor or candor and its breach can have an effect on damages. In the case of Dr. Hari Krishnan, which we had discussed earlier, that was a case on the consent form, but it also spoke about the duty of advice, being candid with the patient. Dr. Hari Krishnan versus Magano Ishak held that essentially the failure to inform the patient that his right eye was beyond salvation and nothing could be done to rescue the situation was important. But in this case, the patient was given, according to the court, was given false hope of recovery when he was made to stay in the hospital for 7 days, to sit whenever possible in an upright position at all times, so that the blood in his right eye could subside. And he then had the hope that he would regain his eyesight, but of course he never did. He was there was a decision, in fact, on the operating table that in order to prevent a painful blind eye, the lens was removed. But the result of that was not informed to the patient, and the patient had lived in hope unnecessarily for a number of days. So in this case, unfortunately for the doctors, damages were awarded, and aggravated damages were awarded for failure to be candid with the patient, for causing him to feel false hope and to feel hopeless thereafter. And this is the highest award for aggravated damages that has been given in this country, of 1 million. No award has approached that since. Another case was this, we had just discussed earlier, Yap Sao Leong and another versus Kerajaan Malaysia and others. In that case, the court found that the doctor had concealed the truth about the obstruction at birth, had concealed the truth through obstruction and oppression by requiring the plaintiff to file pre-action discovery and not producing the record of inquiry into the event. Then the court found that the doctor had prolonged the litigation and delayed the admission of guilt. Apparently, in this case, the guilt was only admitted just prior to trial. And there was also a finding that the doctor incorrectly blamed the mother for the delivery, for things going wrong, for not being able to deliver normally or with vacuum assistance. So in that case, the court awarded aggravated damages of 300,000. Now this case is being appealed to the Court of Appeal. So this decision on the aggravated damages aspect may be overturned. It is not certain. The hearing, my understanding, is at the end of this month. So this case might change. There's another older case, Nur Sharafina Sari versus Kerajaan Malaysia and others from 2019. This case, an award of 200,000 was given for aggravated damages for the suppression of the medical records and internal inquiry report, which was in breach of a consent judgment for pre-action discovery. So basically, there was a consent judgment to provide all the records, and it wasn't fully complied with. So in this case, the court felt that the conduct of the hospital was particularly poor and awarded aggravated damages. Now, how would you discharge your ethical and common law duties of candor? Firstly, you would need to be frank, honest with the patient or caregiver. Be factual when recording or reporting events. As far as possible, record notes and report your findings in chronological order. The chronological order is actually quite useful, because if you jumble up things based on what you recall, when you read it, it may give the impression that one step was taken before another when it may not have been. So recording in chronological order is important, because often in emergency cases, you are recording after the event. So you have time to sit down and think about it, what occurred, and then set it out clearly and in the manner in which it occurred, in chronological flow. The other thing is when you advise patients on their treatments and risks and outcomes, use language which the patient understands. And if it's helpful, use visual aids. You can use charts, you can use pictures, you can even use models. If it's surgery, you might have a model of a backbone or the eye. You can use it and show the patient, or you can draw something down for them. I had a doctor who I quite liked the way he did it. He explained the procedure that he was going to do for the baby. The baby had a hernia. So he drew a diagram on the back of the consent form of what he was going to do. So that was quite useful because when we went to court, we had both the consent form and the drawing of what he had explained at the back. So that's quite helpful. And once you've done the explanation, or you've given the explanation, ask them whether they understood and whether they have any questions. As I said earlier, if it's in a different language, note the record is the language that the consultation was in. And if someone is translating for you, note the name of the person translating. Because if they have given the wrong information, at least you will have had a record of the fact that someone was translating and the error occurred maybe because of the wrong translation. It would actually be helpful in defending a medical negligence claim if it were to come to that. As I said earlier, note any unusual features. For example, if the patient wasn't compliant with the advice or medication previously advised, they haven't complied with their rehab therapy, their physiotherapy, anything that would have an impact on the treatment or the outcome should be recorded. In the event of something going wrong, don't speculate on causes or outcomes. Be factual. Tell them what is known and what are the expected outcomes for the situation, but do not speculate on what may or may not be, unless, of course, it's a certain outcome. Then it's no longer speculation anyway. And be frank and truthful in your assessments. Do not give the patients false hope. As in that Megat Noisha case, the result could be quite bad if the patient is given false hope. And of course, offer the opportunity for a second opinion whenever necessary or possible. As I said before, your notes and reports will form the part of evidence, part of the evidence of what occurred and whether you had discharged your professional, ethical, and common law duties according to the accepted standards of the profession. Now, I'll come to the issue of admission of liability. Often, in fact, all insurance policies generally contain the condition that doctors are not to admit liability to claims. If a patient asks you for compensation, be polite with them. Tell them that you are required to refer all claims to your insurer before you respond to them, and that you will quickly refer the claim to the insurer. Immediately inform your insurer. Tell them about the claim, seek their instructions on how to respond to the patient. Because when you're talking about liability to claims, you're talking about patients asking for money or asking for you to pay for the treatment, or that's what compensation is. Once it comes to questions of compensation, your insurers have to be involved. But also bear in mind that telling the patient that you're sorry about what's happened, empathizing with them, comforting them, is not the same thing as admitting liability. But telling them that I was negligent and I caused injury or death, that's an admission. However, if the patient asks you what's happened, be factual, because you have your ethical duty under the MMC guidelines, the Code of Conduct. You have to be factual and honest about what occurred. Do not mislead the patient. Draw the distinction in your mind between telling the patient what occurred and then offering to be responsible for it in terms of payment or compensation. That's later. Compensation is something that would involve your insurers. But by all means, be clear with the patient what occurred so that they can seek the proper treatment and move forward from that incident. But when it comes to them asking you, did you do wrong? Can you compensate me? Quickly involve your insurers. That is probably the best thing for you to do. What you can do if you're put on the spot, what went wrong? What did you do? If the doctor, if they say, what did you do? What did you do wrong? You can tell them that, look, I will make an inquiry into what had happened, and I will give you a report of what had happened. Because in many cases, there are many factors that could affect what had happened and the outcome. And in telling the patient that I will answer your questions and I will give you a written account, that gives you time to contact your insurer and involve them in any decision on admission of liability, as opposed to telling them what occurred in the case. But liability is about who did wrong. That's a different thing. Yeah. Now, let me give you an example. There's a good reason for insurers telling you not to admit liability, because not all cases are clear-cut. Even when you think it is absolutely obviously clear, there may be other factors or other parties who may have contributed to things going wrong. For example, surgery on the wrong limb. In this kind of situation, the medical profession has come up with procedures and fail-safes to put safeguards into place against an error occurring. So, for example, the safeguards that exist is that the surgeon would mark the surgery site, for example, the hand. The surgery to be done will be listed on the OT list, the description of the surgery. And before the surgery, both the surgeon and the anesthetist check the notes before the procedure so they know what they're doing. And before the patient is put under, the patient is asked or told what the surgery is and what they're there for, at which time the patient has the opportunity to confirm that, yes, it's my right hand or my left hand. Or if they're being told it's the wrong thing, the patient can say, hey, no, that's not what I'm here for. You also have the hospital staff who prepare the operation site and lay out the instruments accordingly. And finally, you have the surgical timeout, where you go through the checklist to make sure everything is in order before you start the surgery. So if something goes wrong and there's a surgery on the wrong limb, one or more of these fail-safes have failed. In those cases, that means liability would obviously fall on the surgeon, because that's the person who did the surgery. But it could also fall on the anesthetist and the hospital staff, the hospital. So legally, more than one person or entity could be responsible for the mistake. And this is why insurers often require that doctors not initially admit liability without reference to them, so that they can ensure that liability is properly apportioned. But of course, the liability aspect must be looked at quickly. And in the case of a wrong side surgery, there's no two ways about it. There is an error. It's got to be addressed quickly. But all that the insurer would want is to make sure that everybody who's had a share in this steps up and takes responsibility. And you can be assured that when something like this occurs, your insurer will move quickly. So that brings me to the end of the talk, and I would be happy to take your questions now.
Thank you so much, Krish. That was a great talk, very enlightening, and I think quite refreshing to cover something on records and medical notes. And let's see if there are any questions there. Please feel free to use the chat box in the comments, in the comment section of YouTube or Facebook. Or you can also use our Slido, all right? And I will, if you have any, I will highlight the questions so that Krish can answer. Okay. So in modern times now, we have technology in the form of electronic medical records rather than handwriting. I think it, to me, although there are a lot of advantages, but sometimes it's a double-edged sword. Do you have any comments about handwritten notes versus electronic medical records in from the medical legal perspective, Krish?
Okay, as a lawyer, I'm very grateful for modern technology because typewritten notes are so much easier to read, because often it's difficult to read the handwritten notes, and I find myself often asking my doctors for the transcript of what they've written. But it's not always possible because in small clinics, they may not be computerized. So as long as you make the notes and it's clear to you, so you're able to transcribe it for your lawyers, that's fine. But I would also make the observation, it should be clear, as a lawyer, maybe I won't be able to understand it, but it must be clear to other medical professionals so that when they look at the notes, they can understand what's said and advise accordingly. Because sometimes you may have a situation where the doctor who took the notes may have passed away, or is not contactable. So anybody who picks up the notes must be able to glean, to get from the notes what occurred at that consultation or that treatment.
So, Dr. Lim has a question. Will a bona fide simplified medical report be taken as a dishonest one?
Something that bona fide means it's genuine, and simplified just means you've shortened it down. If you've shortened it down, if it's just a summary, it shouldn't be considered dishonest. But if a report is written and it's missed out something very crucial that really points towards what the treatment was, or was crucial to the outcome, it won't be automatically assumed that it was dishonest, especially if it was just a genuine mistake and it's corrected later, there shouldn't be a problem. But if it was deliberately omitted, then it would be dishonest. But if it's accidentally omitted, then it cannot be dishonest, it's just an error. As long as it's corrected, it should be fine.
Okay. What happens when notes go missing, Krish? Because sometimes we've got tons of medical notes in the old paper days, and sometimes files go missing. But I tell you, even in electronic medical records, sometimes we have glitches. We think we've entered, and then we find that, oh, it's all gone, a glitch. So what happens? Who is liable? Is it the doctor for failing to keep a backup, or is it the hospital for
it would
failing
depend
to keep?
who has control of the records. Because if you're talking about electronic record, there's two things. Was it entered in the first place? If it wasn't entered in the first place, then that's the doctor's negligence. If it wasn't entered and saved. If it was entered and saved and the record was corrupted or destroyed, then that's the hospital's negligence. But that's negligence in terms of record keeping. It doesn't necessarily mean negligence in terms of treatment or advice. All that means is, unfortunately, that you no longer have a record of the treatment. And then you would be dependent on the memories of the doctors or the nurses who were involved in the treatment, which may not be very useful because you see so many patients over the years. There may be no one who has a memory of what has occurred. And then it would be a situation of, if there's a plaintiff coming and making a claim, there's only the plaintiff's version of events. So if the plaintiff's version is inherently believable, sadly, if there's no notes or records or testimony in opposition to what the patient is saying, it may very well go in the favor of the patient. But it must be believable and consistent with the physiological features of the patient and their outcomes. So it's not impossible to defend, but it would be very difficult. So
it depends on if it all depends on memory, then it's he says, she says sort of thing.
That's right. It's who seems to be more accurate in their memory,
Yeah. The difficulty we doctors have is actually time. And the lawyers want us to document so many things in the medical notes, in the consent form. If you really want to do everything, it will take one whole day for just one patient.
Well, I know it feels like that, but perhaps, as I said,
Mm.
you could maybe create your own short forms
Mm.
or your own form. You might want to have a consultation form that you create with fields for you to fill in, so that saves a lot of time. I mean, if you are an obstetrician, there's certain things that don't change every time, so you can have some standard things and then have the additional bits filled in. Um, but I cannot emphasize how important the notes are. I mean, I'll give you an example. The sample notation I gave you, I actually took it from a case that I did and I changed it a little bit factually. And the doctor in that case was detailed in his notations. And there's just no substitute for accurate notes because he had documented the risks. The risk did eventuate. In this case, there was a nerve injury, and I was successfully able to defend him because
Yeah.
he had noted the risk, he had recorded it down, and it had happened. And on that basis, the court found him not guilty. That's a criminal case, not liable. That was for medical negligence claim. Then there was another case where the patient had, the doctor had advised outpatient treatment. The patient wanted to be admitted because she had insurance. So the doctor happened to note that down in his notes. Of course, when you make an insurance claim, the insurer will ask, so what is this treatment for? Is admission necessary? And of course, the doctor had to be honest and say no. So the insurer refused to cover the treatment, and the patient sued the doctor for the fees because she had to pay it herself. And again, that patient did not succeed because the doctor had noted in his notes that he had advised outpatient treatment, but she insisted on admission. So
Yeah.
it may be a bit of extra effort, but it will pay dividends. It definitely
Yeah.
will.
So I exaggerate, not one whole day, but I think your point is taken. We have templates. You can use templates, checklists. Even in paper form, if you have paper records, we should keep simple templates. Electronic medical records are a great boon. We have just lots of templates, and they just modify and save. Sometimes the failure there is we fail to modify it correctly, and we have
Oh dear.
regular, yeah. So, but we can't delete, we cannot, you edit, there's an audit trail, there's always a date and timestamp, everything. So electronic medical records, I think, are the way forward. So even clinics, you should get a system, even a cloud-based system that are quite affordable, I think, rather than keep old paper records. Okay. Do you just, I think we're running with almost an hour now, so time flies. If there are no question, I just got another quick one because it always crops up every now and then. In fact, one of your colleagues in our previous talk also mentioned. Now, should we record the sessions and encounters, which, to enhance the medical note taking? Should actually document in the recording, for example, the consent taking, or even the clinic encounter? I mean, it's very tedious, and I think there'll be volumes of data. I think
Yeah.
our medical records will scream, if we record everything, even audio. So what do you think?
If
Should this
you
be?
wish to do so, you must bear in mind that you must get the permission of the patients because you
Hmm.
are taking a recording of their consultation. There's a doctor-patient confidentiality there, and you're recording it and you're putting it into the hospital records or something like that. So you must first seek the consent of the patient. If they agree, then only do you do so. Um, I don't think that it's necessary to do it for every single consultation, but there's perhaps benefit for that when you have questionable situations where patient seems to be changing their stories all the time, giving you one set of information at one point and another at another point, and it's looking like this patient will be changing their story as they go along. So in those circumstances, maybe you might want to record, but of course with their permission.
Yeah.
And but but as a matter of course, probably not.
I absolutely agree with you. I happen
Yeah.
to think that patients have a duty of candor too, but often sometimes it just
Yeah.
doesn't happen. So Dr. Aslina has a question, and just just one last question. And would you allow patients or uh, those accompanying patients to record the consultation?
Actually, this is a very interesting question. I got a call by a lady recently on a medical negligence matter, and she started telling me about the various consultations she had with different doctors. And in the course of the conversation, she told me that she recorded the consultation. I said, "Oh, did you?" Um, and then she spoke about the next doctor she had the consultation with, and she had the recording of that as well. So at that point, I asked her, "Are you recording our conversation?" And she said, "Yes, of course. I need to know what you told me." So it could very well be that you have patients recording you without your knowledge. Um, that's unfortunate. Anybody who's recording anybody else should inform them and seek their permission. And to answer Dr. Aslina's question, I think that's very much up to you, because it is your consultation. It is your person that is being recorded, your face, your voice. You have rights to privacy as well, because you don't know what this patient would do with recording. So you could choose to refuse it. But if this is a case of it's a patient who's very forgetful, doesn't remember what they're told, and they're asking, please just to help me aid my memory, can I record it? Perhaps allowing the patient to record an audio of the consultation might be in order, because most of all, you want that patient to go back knowing what they're supposed to do. So if the recording might help, and you think this patient someone you could trust, you could do it. But alternatively, why don't you write down your instructions? Uh, Unless the person is blind, a written instruction is just as good. Uh, for a blind person, an audio recording actually might be warranted, so
Yeah,
that they can
if
play it back. Yeah,
if I may add also, the worry about recording these days is you never know where they end up. Maybe in the
correct.
social media and
Yes,
unsavory
yes,
places, and even maybe
yes,
taken out of context, and it can be
that's right.
uh,
But
uh,
if the
yeah.
recording is being done, the patient wants to record, I would advise you to record yourself at the same time. So you have your
Mm,
own record, and you would know if that recording has been tampered with. So, oh,
okay.
Dr. Aslina has asked something else, is it?
Yeah.
Yeah.
What is your view on doctors who communicate with their patients on social media or phone numbers, WhatsApp, including sending reports of investigations? So that
Oh,
unfortunately fairly common. Yeah.
you
What
have
do you
actually
think?
hit on a particular bugbear of mine. I personally, not everyone may agree with me, but I personally think that WhatsApp is not an appropriate medium for advice, especially medical advice. Because once you WhatsApp an X-ray or a medical report, it can just get forwarded on indiscriminately. People tend to not have filters on social media. Um, I personally think if there is going to be electronic communication, it should be by email, especially sending medical reports and records. Of course, things like reminding the patient of an appointment, that's perfectly fine using WhatsApp. Um, um, or in a case of an emergency, the patient needs to contact you and they're contacting you by WhatsApp. It's a really useful tool, definitely. In emergencies, you use whatever comes to hand to help the patient. But if it's not an emergency, what is the need to provide medical records through social media? How secure is it? It's certainly not. I mean, it's on these social media servers, uh, and every so often WhatsApp has this controversy where they are sharing information with Facebook, and because they're owned by Facebook. Um,
Yeah.
okay, but it's not illegal. Let me put that right out there. It's not illegal if the patient wants you to send it to them in that way. Some patients may not have access to emails. So if they request it and give you permission, and they can't come and collect it, perhaps you could do it. But let it not be your general practice. Yeah.
That's probably a whole talk which I plan to do, actually talking about WhatsApp and should we use it in telemedicine or teleconsultation at all, if at all, and what there's so many pitfalls. Like, do you know really that's the person they claim to be?
Exactly.
Have you identified them properly?
And what if they've changed their phone number and you're sending records?
Exactly.
Yeah,
sending to some brother-in-law or sister-in-law who's trying to fish out some data about the patient, and that may be misused. Anyway, there are a lot of pitfalls with social media. We generally try to tell doctors, don't use WhatsApp for telemedicine. Better use their proper telemedicine platforms where there's proper identification, secure transmission, and data is not being mined by Facebook. If it's something which people are just not worried about, I'm very worried about it. Even email, if it's not encrypted, is probably not PDPA compliant, I think. So we have to, that's food for thought. If you send sensitive health data in an unencrypted channel, maybe we should not be doing it at all. But anyway, that's outside, I think, today's talk. But I think we've really stretched for time, and I think we really need to not take too much of Krish's time. And I just want to finally thank you very much. So I'm going to, I haven't forgotten to show the QR code, don't worry. I did it once, I've actually forgot to show the QR code for points, and people got upset with me. Okay, so this is the QR code. Let me put it into presentation mode, all right? So what our doctors do is they will take the MMA app and then they will scan the QR code, and they should be able to get 1 point. So it's fortunate that lawyers don't have to have compulsory CPD today, or am I?
Oh, no, we do. We have compulsory CPD.
Oh, okay. Yeah. Let me see. Everybody got their points? Let me check the Slido. Yeah, there were no questions on Slido. And the poll, I think, let me check the poll. There were some votes after that as well. Half were medical officers and 20% were GPs, 11% were specialists. So that's who were watching roughly, rough proportion. Okay. All right. I think I won't take too much of your time now, Krish. I'll leave the QR code there displayed for a while more, so give people some time to scan. If you can't get the points, because the QR code has expired, you can visit the DOBBS Bulletin Board. There's a CME section there, and tomorrow onwards, you'll have the MCQs active. And you can watch the video and then pick up the keywords and answer the MCQs to claim the point. Okay. So thank you. Just a last word, Krish. Would you want anybody be able to contact you?
Yes, certainly. Right. I didn't put the information up.
You can put in the chat with me your email, perhaps. I can just your private chat there, and I'll put it as a banner. So it'll still give you time.
Yeah, there you are. Okay.
Oh, God, that's nice and short and sweet. Short and sweet, yeah.
Yes. Thank you so much for having me. It was my pleasure to come in.
Thank you so much. Yeah. So if you want to contact Krish, you can actually reach her at chris@muralipillai.com, and that's, if you go to the website, you'll find more about the firm. Okay. All right. So wish you good night. Stay safe, stay healthy, and thank you again very much for that very informative talk. And I think you've answered some of our questions and reminded us on what we need to do to practice. Yeah. Okay. Good night.
Okay, thank you. Good night.
Bye. Okay, guys, I'm back. A number of you are saying invalid QR code. Let me check. Okay, hold on. I will check. Apologize. Yeah. Let me regenerate it again. I'm also getting invalid QR code now. Okay, let me generate again, save as PDF. Can you see this? Can you try scanning this one? This is freshly generated. Let me try again. Oh, I'm getting invalid QR also. I do not know why, guys. I'm so sorry. I'll have to bring this to the MMA. I tell you what, if you have gone through the talk, you can either email the keywords to me and put your, or you can WhatsApp Candor DOBBS. Hang on, let me put up a banner. Yeah, there's something wrong with the QR code. I've generated it fresh from the MMA CPD portal, and I'm quite sure that's the one. Yes, it's supposed to be. The QR code is not working. Yep, it's not working. So this is a freshly generated QR code, and if you can't, then what you need to do is to email me here. Okay, all right. Or you can WhatsApp me. What you do is just email your the code words which you've seen through the talk, and then I will manually upload the points for you. So sorry, I will put up the MCQ. So if you don't want to do that, you can do the MCQs using code words tomorrow in the bulletin board. Okay, I'll try to come up with something easier, also like a simple form, and then you'll go into a spreadsheet. But that's I don't have time to do that just now. You can also WhatsApp me. This is my WhatsApp link. Hang on a second. So if you don't want to use email, you can also WhatsApp me using this link, wa.link/DOBBS. Okay. All right. So my 1,000 apologies. I'm not sure why the code didn't work, but we'll have to troubleshoot it with the MMA IT team. Okay. So just email me for manual upload of your points. Just I will ask the details from you, and if you're registered DOBBS, it's a lot easier because we have your MMC number and so on, and we'll manually upload the points for you. Okay, so you can try again. I really myself also I couldn't scan the point. It's not working, and might be a technical glitch. Yeah. Yep, not working. All right. Apologies. Okay, good night, everyone. We're going to end the broadcast now, yeah?